because I think they were inherently rushed. So last week we did the Obrien line of cases. We did Obrien, which was about draft card burning. Texas against Johnson, which was about flag burning. And we did RAV versus St. Paul, which was about burning a cross. Ultimately, the court found that in some of those cases, the conduct was expressive, right? It was designed to express speech in Johnson and in RAV. But Obrien itself, the court said that the state had a greater interest to regulate that speech because it had a sort of administrative purpose, right? The law was designed to preserve records. Okay. But in RAV, the court struggled a bit because there were a lot of precedents that didn't quite seem to neatly line up. A number of you picked up on this last week. For example, we have the fighting words doctrine, which says if you engage in some sort of words that might draw punches, that speech can be prohibited. And a lot of you ask, how can you reconcile Czaplinski, the fighting words case, with RAV? And it's a good question. I think the short answer, the perhaps real answer, is Czaplinski is not really good law anymore, and the court is ignoring it. But the court tries to give a better answer. And Justice Scalia, who wrote the majority opinion in RAV, explains that the sort of regulation at issue in St. Paul, Minnesota is different. How? It only prohibits cross burning for certain types of expressions. For example, if you burned a cross to express racial hostility, that would be banned. But let's say you burn a different symbol. I gave one last week. Let's say you burned a wheelchair. I don't know why, but let's say you burned a wheelchair because you hated disabled people, right? Burning a wheelchair would not give rise to liability. And Scalia says this is a form of viewpoint discrimination and content discrimination. Now, what's the difference between the two? With content discrimination, you are suppressing a certain type of speech. So, for example, speech that is critical of the government, right? Imagine you have a law that says you cannot criticize the government. That is a form of content discrimination. It doesn't matter if you are in favor of the Republicans or in favor of the Democrats. Whatever your viewpoint is, you can't criticize the government, whoever's in power. Okay. But then you have a viewpoint discrimination, which might say you cannot criticize Democrats. Criticize Republicans all you want. You can't criticize Democrats. That's not a content restriction because you can be critical of the government, but only from one perspective. Viewpoint discriminations are also prohibitively bad. Now, come back to my hypothetical. You're allowed to have speech that's perhaps in favor of disability rights, but you can't have speech that's critical of disability rights. So really only one side of the ledger is permitted. You can have one type of speech, but not the other. Okay. The difference between